Our first concurrent session of day 2. I'd like to welcome Judge Lori K. Smith, who will be speaking on trauma-informed justice, addressing and reducing court-induced trauma for litigants, witnesses, and jurors. Chief Judge Lori K. Smith has served on the Washington State Court of Appeals, Division I, since August 2018. Prior to this, she was a King County Superior Court judge for more than 6 years and a commissioner for 6 years. Judge Smith has been a key figure in improving the judicial system, co-chairing the Minority and Justice Commission's Education Committee and the Gender and Justice Commission's Tribal and State Court Consortium. She has taught at Judicial College, presented at various judicial conferences, and has been involved in mentorship through bar associations and law schools. In 2011, she and her fellow commissioners received the King County Washington Women Lawyers Judge of the Year Award. Before her judicial career, she worked as a senior deputy in the Family Support Division of the King County Prosecuting Attorney's Office. Welcome to the stage, and I'll let you take it away, Judge Smith.
Thank you very much, Lauren. I'm really excited to be here. This is a different sort of thing for me. Typically, I speak in front of judicial officers or sometimes at schools. So this is a different place for me to speak, but I'm really happy to be here. I'm going to give you just a little bit more about my background, talk about the evolution of the court's understanding about how trauma impacts our litigants and our court and our decisions, how we have learned to understand the effects of trauma and to recognize its effects on our system, what the future might look like, and then questions. I do have to do a disclaimer. Anything that I say is only from my perspective. I'm not speaking for the Court of Appeals or my fellow judges at all. So a little bit more about my background is that I started off as a prosecutor in the Family Support Division and did a variety of things, but a lot of family law cases that involved children and involved parents and people in crisis. And it was from the time I started in the late 80s up to now. Oh, that reminds me that I'm supposed to describe myself. I forgot to do that. I'm an African-American woman. I have natural sort of curly hair. I am in my 60s, and I'm wearing a maroon sweater that has some black stripes on it. So when I was at the prosecutor's office, we were dealing with people who were in crisis, dealing with the things that are most precious to them, their children and their finances. And we realized that how we dealt with them had a lot to do with how they responded to us and the cases, and that we were able to get a lot more settlements and a lot more cooperation between the parties if we were more inviting. And it was sort of the first time that I recognized that the trauma, the stress, the strain that people were going through directly affected their outcomes in court. We also did some criminal cases, and one of the types of criminal cases we did was welfare fraud. And there were oftentimes defendants in welfare fraud cases who were victims of domestic violence. And some of the reason why they were doing things, earning money and not reporting it, was because their benefits were being stolen by their intimate partners. And there were times when I was able to convince my division chief to reduce their charges from a felony to misdemeanor, which had a huge impact in their lives in the future. And that also was a time when we recognized that a lot of the downstream consequences and things that happen in a person's life are directly affected by what they are going through in that moment and in their childhood. When I became a family law commissioner, I was on the domestic violence calendar for the first 2 years as a commissioner. Every morning, I had a huge calendar of that dealt with intimate partner violence. And many of the people who came before the court were people who were not born in the United States, that were entrenched in communities that were very culturally segregated, and it was a Herculean effort for them to get to court, to be able to fill out the paperwork, to be able to stand there and tell their story, because they were risking cutting themselves off from not just their intimate partner, but from their family and their community. Recognizing that and what was going on with them helped to sort of understand how they presented in court. The other thing that we realized is that in a lot of those communities, they were so small that the interpreters were oftentimes enmeshed in that community as well. And I'll never forget the first time one of the petitioners talked for at least 45 seconds, and the interpreter interpreted that what she had said was nothing happened. And I realized then, and she looked at him like she knew that she recognized that was not true, but she didn't say anything to me and didn't refute that. And it was just a recognition of how difficult it is for someone to tell you their story and get everything across just by words, that we have to look at them, we have to look at the situation and incorporate that into our fact finding in those situations. Then I became a Superior Court judge, and I was a Unified Family Court Chief Judge for a couple of years. And in that role, I was able to work with our partners in the court. And that was very helpful, because a lot of the things that we wanted to do, changes that we wanted to make, and avenues that we wanted to explore with regard to a lot of things, we were coming from our perspective, when really we needed to be coming from and understanding the perspective of the people who were coming to court. And a lot of times there were things that we weren't aware of. I remember one meeting we had with people from various communities, and they were trying to explain to us that oftentimes when people were in court and they came from other countries and other where the judicial system is very different, they may be afraid of us in general. They may be afraid to disagree with us. So when we say something, they're nodding in agreement, we think, but in fact, they're just nodding because that's the polite thing to do. Also, telling a story is very different in many cultures. We're so pressed for time in court, and we think people are not answering the question because they're giving us some information prior to that, but really that's their way of answering the question. They are not trying to not answer the question, they're trying to answer it fully, and recognizing that and not being sort of judgmental or sharp with them for that is important, because then they shut down. It was just an interesting situation to be in, to learn a different perspective about what was going on in the court. And then I came here to the Court of Appeals, and the Court of Appeals is a reviewing court. We review what the trial courts do. And in this instance, we're just looking at transcripts. But it's interesting, when you look at transcripts, you can sort of see where things get off the rail. When you're in court as the judge, you're trying to manage everything: the jury, the lawyers, the witnesses, the parties. And sometimes you can be so focused on that job that you're missing some other things that are happening in the courtroom. We, at the Court of Appeals, we slow everything down, we read the transcript, and oftentimes we can see differences that the trial court wasn't aware of. And it's an opportunity for us to inform and to correct some things if there is an actual error and that contributed to it. The court's path to recognizing the effects of trauma was a little slow. We've always been aware that trauma is experienced due to intimate partner violence, being a victim of a crime, and children in the child welfare system. But some years back, there was a recognition, sort of a light bulb moment, that if children had trauma when they were in the welfare system or in family law cases, then perhaps the juvenile offenders were suffering trauma as well. And that might actually be part of the cause of why they were behaving the way that they were. And in fashioning remedies for them, this is something that we should be looking at. The adverse childhood experiences that children experienced when they were in the child welfare system really had a direct result of their behavior later on. And the first large-scale study was a survey of about 17,000 people that was done between 1995 and 1997. And no surprise there, it found a direct correlation between childhood trauma and what was happening in the juvenile offender arena. And then, no shock, obviously, that those juvenile offenders grow into adults. They still have that trauma with them. And that also can play a huge role in them being in the criminal justice system and what happens to them there. 90% of adolescents and 75% of adults in the U.S. criminal justice system report at least one traumatic event during their childhood. I had a situation where a defendant was being sentenced. He had pled guilty to a violent crime, and he was going to go hit his offender score, which is how in Washington State we have a method of sentencing individuals that is directly related to their past criminal history. And offenses are scored, and the higher your score, the longer you would be sentenced. There's still a range in there, but it goes up depending on your offender score. And his offender score was really high, so he was looking at a lot of time. And we were in the courtroom. He was the last person who was being sentenced that day, and we were in the courtroom, and his offense was really violent against a male someone that he didn't know. And when you sentence someone in Washington, you have to give them the ability to talk to you, to say things that they want to say to you before you sentence them, things that judges are supposed to consider when they're determining whether or not or how to sentence them. The prosecution has the ability to let the victim speak, and then the defense has the ability to the defendant to speak for themselves. So we got to the point where I asked him if he had anything to say, and he was a huge African-American man, he looked very angry initially. He asked if he could stand. I said yes. He stood up, and he told me then that he was going to tell me something that he had never told anyone before. And he proceeded to tell me how he had been the victim of child molestation for years as a child. And that it just occurred to him after this last run-in with the law, and after having two little girls, that his anger over that happening, over no one saving him, over no consequences with regard to that, had informed his entire life. And he had been angry and acting out from the time he was a child up until the last crime that he committed. He was very tearful. He was literally crying. And he said, I just want the opportunity to be able to show my children a better world, and that love doesn't have to be violent, and that, and to be a good example for them. It was an incredibly moving experience for me, for the jail officers who brought him there. And I sentenced him within the range because that was my job. But I told him that, this was the first step for him, and he could still be a good father to his daughters and an example, even though he was serving time in prison. And that I appreciated that he felt comfortable telling me that, and that was a huge step for him. He can't be the only one who is in that situation. A lot of times, their background, their pre-sentencing reports, and what the defendants have gone through. But it was interesting to me that there was nothing in his pre-sentence report about that. He truly had kept that bottled up forever. And it reminded me of another situation where a juvenile offender was given an opportunity to speak before he was sentenced. And he said that the only reason that he started, and he was running with a gang and had done some pretty violent things. And he said the reason that he started doing it is because his parents were in such a violent relationship, and they just weren't paying any attention to him and his siblings. And he was looking for a sense of belonging and also for attention. And he said it just got out of control. And he wished that someone had seen that he and his siblings were suffering and had helped them. And it just makes you realize that there are probably points along the way in the judicial system that we could have helped. We could have reached out. We could have done something. And the first step in that is for the court to recognize first the effects of trauma, how trauma shows up in our courtroom, and that we actually have the ability to do something about it. Most judicial officers are very concerned about not doing something wrong, in the sense that we are favoring one side or the other, that we are not being neutral, that we are not being a place where everyone feels that they're getting the same sense of justice, which is ironic because a lot of the things that go on where we aren't recognizing trauma and how it affects people, and that some of the behaviors that we're seeing in court and in the cases in front of us are directly related to that, makes it so that we actually end up not being this safe place for everyone to come, where we recognize and we put people on equal footing by knowing their background. But there is a concern that if you appear to be favoring victim or a witness or the defendant, that you're not doing your job, and that everyone who has eyes on the court system and us as judicial officers need to see us as being neutral. But part of that, I think, is because it's taken us a while to get to the idea that everything that is happening to an individual is part of their story of how they got there. And it may not be that the outcome is completely different than if you didn't know that or you didn't take it into consideration. But sometimes just seeing someone, acknowledging someone, and giving someone words of encouragement, that you understand that this is something beyond just you acting out or recognizing that resources and the opportunity to do something different isn't within the grasp of everybody, can go a long way to helping people get past the experience of being in court and make better decisions in the future. We've always been aware of the trauma associated with intimate partner violence, being a victim of a crime, and children in the welfare system. But it's really been an important step to recognize that everybody involved in the court system probably has some degree of trauma. And how litigants are perceived and how their behavior is perceived is directly related to the services that we're providing and their experience in court. And if we really want everyone who is coming to our court system to feel that they have access to the court and that justice is there for them. We've got to recognize this. And there, more and more, we're understanding the different types of trauma that show up in court. We're recognizing that there's racial trauma that can cause chronic stress, anxiety and depression, mistrust, and post-traumatic stress disorder. That economic inequalities that not only influence culture, but values and behaviors and social interactions. That gender inequality adds to stress due to less financial resources and opportunities, and that sexual orientation discrimination can lead to violence and threats, and people are hesitant to put that information out there because they're concerned that it will only create more of the same. When you take a step back, and the courts have done that recently over the past 10 years or so, we've recognized that everyone coming to the court probably is dealing with some sort of trauma, and that the court experience might just be the thing that's exacerbating that rather than helping them to get past it or having some recognition of it as we're dealing with their cases. We have done a lot of education in Washington surrounding trauma, surrounding the social economic concerns and inequalities, DEI, and implicit bias, because we want the judges to recognize that as we're making these decisions, you should be looking through the correct lens. And if you don't slow down and recognize that all of these things are happening in this courtroom when people come in and start speaking to you about their situation, and when you're making a decision about family law matters or child welfare matters, criminal cases, that if you aren't aware that part of what is going on are those things, and part of what you are seeing is directly caused by those things, then you just simply see it differently. You see the result of the behavior rather than how you got there in the first place. And it may cause you to treat people differently. It may cause you to be biased or unfair, or just simply to not give people that open feeling that they are being heard, that the court is a place where we are trying to administer justice, and that we recognize that that the system is part of the problem here. We also have recognized that the people who work in the system are dealing with the effects of vicarious trauma, and that they have their own trauma that they're bringing to the situation that's affecting them. And sometimes their reactions when they interact with people who come to the court is a direct result of that. And that can certainly put someone who's coming to the court in a completely different mindset and feel as if they aren't going to get justice there, that they aren't going to get understanding there, and that even the person at the counter thinks that they are less than, not important, isn't listening to them, and won't help them when they believe that the very purpose of the court system is to help. When we've been thinking about how to address the issues, we recognize that training is a huge part of it. And not just training how to recognize that it exists, how to recognize it, but also things that you can do in the court setting that won't put you in that place that judges are afraid to go, where they feel as if they are treating someone inappropriately special because of that, instead of just recognizing that who they are and treating them like a human being so that the best result can happen. since court is inherently traumatic, we have to just look at it from that point of view. It's a adversarial process, and the outcome is always uncertain. The people who come there are very vested in what's happening. They are putting their faith that the system, that the court will see them, will hear them, and at the end, the right thing will come. The result will be right. The process and the terms used are difficult for people to understand, and even more so if English is not your primary language, and if you are working through cultural differences as well as a language barrier, and the process is moving really quickly. Even if you have the opportunity to have an attorney, most people are still confused by the proceedings. There are certain circumstances where people are actually entitled to have an attorney: criminal cases, child welfare cases, involuntary treatment, commitment for mental health issues. They have appointed counsel, but most people have to pay for their own attorneys. And even if they have enough money to start out paying for an attorney, the longer the case goes on, the fewer people who are able to retain an attorney throughout. And an attorney, while you do have to pay them, they are able to not just represent you in court, but also sort of explain to you what's happening. And as we have gone forward in society and we've had shrinking resources, one of the first resources legally that has been has evaporated to a great extent are the lawyers, the civil lawyers who were helping litigants. It's very difficult to find a lawyer that you can afford and be able to keep them. And there were places before that you could get lawyers to help you, but the majority of family law cases, both parties are not represented. And if one starts out being represented, if it goes all the way to trial, usually the lawyers have fallen by the wayside. Domestic violence protection orders, very often the petitioners are not represented. A lot of courts, like King County Superior Court, have advocates who work with the petitioners. And there are a lot of community advocates, which are sometimes even better because they understand the cultural differences, they understand the language barriers, they can work to help get interpreters to the courtroom. It's the job of the court, but sometimes they're difficult to find, and they can provide that resource. More often, the respondent in the domestic violence protection order will have an attorney than the petitioner. There are collection actions where people they can't afford to pay their bills and they've been sent to collection, and there are firms that specialize in buying those for pennies on the dollar and then going after and getting judgments against people. There's a process in the end where they come to court, and there we have recently recognized and provided an opportunity for the person who is the respondent in that case and the firm to have a conversation to see if they can have a resolution of a lesser amount in order to get that, to avoid having that judgment against them. And it's amazing to see, because the firms, because they've bought it for pennies on the dollar, they're oftentimes very willing to negotiate, but they have no incentive to do so unless the court says, hey, we're all here. I want to see if you can go back in the jury room and figure out if you can come to a resolution. And then the person will always end up paying less in that situation. There are even some pilot projects where they're trying to get that to happen before you even get to the point of going to court. And some of them have been successful. There's also eviction cases, which, after the pandemic ended and all of the stays on those sort of actions came to an end, there was, a huge influx of tenants being evicted. And the tenants tended not to have lawyers. And the situation was problematic on both sides. Clearly, the landlords hadn't been paid, but also the tenants were in a situation where not just them and their family, but all of their belongings were about to be set on the side of the road. And just having an opportunity to have a discussion wasn't really happening. There are some pilot projects now in Washington State, and there's also some legislation that gives lawyers to the tenants to try to figure out what is an appropriate, even if it's just giving them more time to be able to figure out where they're going, how to get their things there, if they can get some other housing before that. There's oftentimes disputes with regard to how much is really owed and what really happened. And when you don't have a lawyer and you're worried about your belongings being on the side of the road, it's not inducive to being able to negotiate. So having a requirement that happen has really helped in that situation as well. And then just the mere fact that when you come to court, language is just different. And I'm talking about if everybody speaks English and it's their primary language, language is different. There are terms and phrases that are used in court that people who are in court all the time understand, that people who come to court are confused by. And there's very little effort has been made in the past to explain things to them and let them understand what those words mean. There was a huge push, goodness, it's been probably 20 years ago now, to have pattern forms for family law cases. Family law was the avenue that people were looking at first because so many people were representing themselves in family law cases. And at the end of a family law case, people's contact with their children, what debts they would be responsible for, what they would have to pay in child support, receive in child support, what spousal maintenance was paid, was all decided. And a lot of this was decided without an attorney in sight, based on information that the parties cobbled together, and the court would have very little information and still have to make a decision. So there was a huge effort to make these pattern forms so that all the forms, everyone would use the same form. The forms would have plain English, plain language forms, so that people could understand them. And there were then resource centers where people could go and talk to court facilitators about how to fill out the forms and how to file their motions. It was very helpful from the standpoint of being a judicial officer and seeing the orders after the pattern forms came out and before. They were much more complete. But there's still the issue, even with pattern forms, that there is, if you are in a traumatic situation and you are running to court trying to figure out how to get a temporary order so that you can be the one who stays in the home and you can have money to help keep that home running, sometimes even filling out that form is difficult. And certainly if English isn't your primary language, that makes it difficult as well. There are pilot projects now around the state for self-represented parties in all sorts of areas of the law, to help them fill out the forms, to help them with interpreters if they're needed to help translate the forms, and to help them move on and get their cases started. We have a session at the fall conference, which is in just a few days, that is going to talk about the dearth of lawyers in civil cases, the fact that these sort of self-help places where people not only have self-help, but they also have people who have good knowledge about the area of law can help them fill out forms and get started, just make a huge difference. And the fact that when we look at who suffers the most due to the lack of resources in this area, it typically is BIPOC communities, people of low income, and people who are immigrants to the United States. And again, if we're really trying to figure out how to do justice in our court, we should make sure that we have access, that everyone has access to the justice that is being done there. So then we're figuring out change. And of course, change first starts with the judges, because we need to be able to set an example so that everybody else in the judicial system will recognize that we are on board, and our expectation is that everyone else will do the same. Just because court is, by definition, an adversarial process doesn't mean that the court itself should be an adversary. And it doesn't mean that we can't encourage people to try to see if they can come to a resolution. And that, encouraging them to do that, part of that is recognizing sort of where they're at and what they need. We have a lot of training for judicial officers in Washington State. We have judicial college, we have conferences, they attend outside trainings, and people have really taken advantage of that. Everyone is looking at ways to reduce trauma in their courtroom. As I said before, it was a little bit of a hard sell at first because people were concerned about, am I doing too much? Am I helping too much? Am I going to be in danger of violating my judicial ethics by doing this? And of course, there's a way to do everything. But we have to train everybody. We have to train court administrators. And there are conferences specifically for court administrators so that they can understand trauma and how it looks in the people who are working in the court system, and offering training for them, like clerk's office employees who have a lot of contact with the public, a lot of people coming to a counter, not knowing what they need, not knowing what to ask for, and giving them the skills to be able to slow things down and help those people. Even the screeners and the security officers, the very first people that you see when you come to a courtroom, a courthouse that has security, it's pretty intimidating. There's a metal detector, there's an x-ray machine, there are people in uniforms. Simply just smiling and greeting the people as they come in contact with that can help reduce the anxiety that people have about that situation. And then the bailiffs and the courtroom clerks interact with the litigants a lot. And the hope is that that they will be cognizant of the fact that there's a lot of trauma going on in the courtroom, and that we shouldn't exacerbate it by being short with people, not understanding that it is new to them. It may be something you've done forever, but it's new to them, and giving them just a little leeway. Attorneys that are in court a lot, prosecutors, defenders, family law attorneys, and experts who testify, sometimes they will reflect the culture of the court. So if we are slowing things down, explaining things, being welcoming to people, they will have that attitude as well. And when we're looking at changes to the courthouse, there are lots of things, little things like signage, where you place it, using pictures, having more than one language available that give you some signage, having kiosks where people can put in their language and get information. Even lighting and artwork has been shown to have an effect on how people feel when they're coming into a courtroom. I had the fortune to be able to go to Guam to help train their court partners about domestic violence and what that looked like, and what the litigants would look like coming into court. And we were dealing with judges, commissioners, bailiffs, clerks, law enforcement. And it was interesting. One of the things that we did is we pretended to be litigants who needed a protection order. And so we went in and sort of went through the process. And everyone was very friendly and welcoming, but we just realized that where signage is placed has a huge effect. When you go to the counter and you don't know what you need to ask for, having someone be patient and sort of maybe walk you through with some suggestions about what you might be needing and asking for was so helpful. It just showed you like this whole different, even though we knew the process, trying to get information about the process was really eye-opening for us. And that's happening to people every day in courtrooms all across the United States and probably the world. What we have recognized now is that what we do in the court surrounding a trauma-informed approach can literally change people's lives. In order to really give people access to justice and not have it depend on their finances, what language they speak, means that we have to be welcoming and recognize that that there are things that have to be done that invite them in rather than exclude them. In order for court to be viewed as a safe place, it actually has to be safe. And a lot of the physical safety of the court has been dealt with, but it needs to be safe for people who are unsure, who are emotionally distraught, who are trying to figure out how to proceed, to be welcomed, and to get information that will help them be able to move forward. And we need to look through the lens of the people who are coming to figure out what's important for us to do to help them, given their trauma, their culture, their language barriers, and their fears. Also, to actually feel as if they are being heard. And small things, there was a push at one point for reviews in the child welfare system where parents were supposed to do certain things and then come back and there was a review to make sure they had done those things in the steps towards getting their children back. And there were so many cases, and there was this idea that you had to just sort of rush through this review. And for many of the reviews, that was fine. Someone would say, here's my proof that I've done what I was supposed to do. The judicial officer could say, this is great, continue in this path, we'll have another review. But when people hadn't followed through, that was really the point when you needed to slow down and have an interaction and also figure out what was going on in their life in that moment as to why they hadn't been able to follow through, instead of just dinging them and moving on. And that sort of is the process that we need to be looking at constantly in court. Why is this happening? Not just looking at the effects of what is happening, not exacerbating the stress and the situation by what we do and how we interact with people. And also fashioning remedies for these things that take into account cultural differences, recognize the historical framework that a lot of this exists in, and the gender issues and sexual orientation issues that are front and center for a lot of people and could have influenced how people got there. One of the best ways for the court to figure this out is to invite other people in. When you wear a black robe and you're making the decision all the time, you take that responsibility on, and it's a serious responsibility, but it doesn't mean that you actually know all the answers. And a lot of times there are community partners who can help with that and are necessary. They're critical in fashioning how we get to a trauma-informed court and what their their community needs in order to feel safe and heard in the court. We can imagine a different situation for our court systems, and we're doing it more and more. But it starts with recognizing that we need to work with other people, community partners, to make it. We have some things that have happened recently, and I'll just go over a few of them as I finish. The recognition that children are different when we're dealing with juvenile offender cases, even when they are being tried as adults, is huge, because the whole idea that the brain science that tells us that their brains aren't fully developed until probably 25 years old, and that's part of what is going on, means that we should be treating them differently, and also that there is hope for change in them really soon, that we can, if we treat them while they're in detention, we have the opportunity to change their future and help the community as well. There are court rules that have been enacted to make sure that people can serve as jurors, because part of being part of this community is allowing everybody to be part of the civil process, the criminal process, the court process, and that's serving on juries. And a lot of times there would be questions that people in BIPOC communities would answer one way, because we have a different experience with law enforcement, with financial situations, than people who are not in BIPOC communities. And there are challenges that lawyers can make to those individuals, that you don't have to say a reason why you don't want them on the jury. You just excuse them. And we figured out that a lot of people were being excused who were from the BIPOC community, and there had to be no reason given for that. And that meant we weren't able to serve on a jury like everyone else. So there was a rule, GR 37, that said, if it seems like this might be racially motivated, then there needs to be a discussion about why are you excusing this person, and you have to show that it isn't racial motivation, so that everyone gets to serve on a jury, which then makes people who are being judged by that jury feel like it really is a jury of their peers. I think I mentioned before that tenants in eviction cases are getting attorneys, because that is such a final situation, and not having an attorney was just basically, it was a fait accompli for them as to what the result would be. And then lastly, there's case law that talks about how we are going to discuss and treat people who are testifying in trials and people who are parties in trials, and that we can't use stereotypical language and racial negative stereotypes to describe them or describe their behavior as a way to get the jury to not rule in their favor. And it's a sticky situation, because you really put the court in a position of saying, was this an effort to play on those implicit biases that we all have, or does this really have something to do with the case? So that is my talk. If you have any questions, I think we can take them now.
Yes, we have a few minutes to take some questions. So I'll start with, how can the people providing services help people prepare to bring their trauma forward in the context of the courts?
I think that part of it is there are obvious opportunities to bring it forward. If you have a declaration or you're testifying, there's an opportunity for you to say, to bring that to the court's attention. But a lot of times, I think what needs to happen is that people need to recognize that the court has an opportunity to hear those things, but you might have to mention it in a situation where you aren't given the opportunity to put a declaration forward. Like in a situation like the gentleman that I said who I sentenced, there was a pre-sentence report that had nothing about that, but he took it upon himself to let me know that happened. And sometimes you just have to make your own opportunity to do that. And having someone in your community give you the thumbs up and the encouragement to do it, I think is helpful. The court should listen and hopefully will listen.
Right. I know that story resonated with me and a lot of people in the chat. I was really touched by that. And I saw somebody in the chat saying, thank you for sharing that. So I just wanted to bring your attention to that. Also, somebody in the chat said she's my new hero. And a lot of people are just saying thank you and are just very, very appreciative. So I just wanted to let you know. The next question, in your experience, what would be a good approach for people coming into the court system to bring their trauma history to the attention to the courts that are not trauma informed? You kind of already, well.
Yeah, it's hard when the court isn't trauma informed, because you don't know if the judicial officer or the court system is concerned, like I said before, that they are giving special treatment to people if they hear about their trauma or comment on their trauma. But I think that it is hard when you are someone who shouldn't have to put up the fight. But the bottom line is, if everyone who felt comfortable would say, this is what has happened to me and this is what I'm going through, I think people who are concerned about a court leaning too far in one direction or the other would recognize that this is an everybody problem. There are very few people who have no trauma, and
Right.
particularly who are coming to court. I mean, the people who use the court system, just using it is traumatic. And so I think it never hurts to put it forward. And frankly, from my court, the reviewing court, if we see that should have been considered and is in the record, then that could be a reason why we say there was an abuse of discretion to not consider this and send it back.
Right. Just to your comment on saying that being in the court system is traumatic, one person made a comment. Just a comment that slowing things down a bit can really help. I am of the dominant culture and I'm not the defendant, and court goes so fast and I always feel anxious. Okay, the next question. It's great to hear you talk about judges realizing they need to take a trauma-informed approach. How can we get this mindset more embedded with the prosecutors whose focus tends to be about punishment rather than accountability with help?
I remember I had a case where there was a medical issue, and there were two doctors, and one was a surgeon and one was an internalist. And they both said different things. The surgeon said, oh, there needs to be surgery right away, and that's why we did the surgery. And the internalist said, hey, there could have been medication to take care of it. And the attorney in their closing said something to the effect of, everybody sees it through their own lens. Like the surgeon, all they see is, I know how to do surgery. Surgery works. We're going to do surgery. And the internalist says, no, medication is that. And so we need to do medication. And I think this is sort of that situation. When you have a focus where this is how you think things work, then you're sort of stuck in that situation. And education is the only way. And we have had, with the judiciary in Washington, it's interesting to see the evolution from the time I was a commissioner to now, almost 20 years, that before there were people that were pushing back that would verbally say, no, that's wrong, we can't do that. And now we have people saying, well, we need to figure out how to do that better. And is it all right? Let's talk about whether this is a violation. Can we do this? So it's really taking a change. And some of that has to do with the judiciary is looking different than it has in the past. I'm the first African-American woman to ever serve on an appellate court. in the state of Washington, and that didn't happen until 2018.
Wow.
And so there's more and more people from the BIPOC community who are from the LGBTQ plus community who are judicial officers. And I think that has made a big change. And then differences in life experiences. So you recognize that.
Right. Well, unfortunately, we can't get to the rest of the questions, but this was so wonderful. Thank you so much, Judge Smith. The chat has been very active, so go ahead and put some hand clap emojis in the